Hi there, good evening. Welcome to the fourth episode of the Utsav Mukherjee Intellectual Property and Technology Law Show. So, for those of you who are watching my show for the first time, this is a video series on intellectual property and technology law developments in India and around the world. I am an intellectual property and technology lawyer myself, affiliated with a law firm here in New Delhi. Any of the views or opinions that I express during this show are mine alone and not that of any other person or entity. So today's episode is about something which will interest a lot of people, particularly those who like the world of finance and its interplay with technology. Today's episode is about the legal and regulatory developments around cryptocurrency in India. So this topic is particularly of interest to me because in the past, about more than a year ago, I had rendered some legal advice on crypto-related legal issues in foreign jurisdictions, such as compliances that cryptocurrency issuers have to carry out in places like the British Virgin Islands under, say, the anti money laundering regulations or the counter finance terrorism regulations. So, to give a brief understanding, basically, these are the kinds of regulations that foreign jurisdictions such as the Cayman Islands or the British Virgin Islands have in place because crypto is a tool which is often used by some people for money laundering or say even financing terrorism because it is so anonymous. Although that doesn't make crypto a bad thing because it's also very much a great asset in finance, but it does have its controversial elements, right? So basically, whenever anyone issues cryptocurrency in these foreign jurisdictions, they have to comply with these laws so that these jurisdictions are then sure that at least there is no terrorism being financed or money being laundered through those cryptocurrency exchanges. So now at the very outset, let me first explain to you what is a cryptocurrency. A cryptocurrency is a digital currency which is an alternative form of payment created using encryption algorithms. It is a medium of exchange and is a form of payment, right, which is decentralized because it does not depend on any central authority such as a bank to maintain it. It in fact works through distributed ledger technology such as a blockchain, and no one person owns or issues these decentralized cryptocurrencies. Now, the very first decentralized cryptocurrency, which till date remains the most popular in the world, was Bitcoin. And they have issued some centralized cryptocurrencies also after that. Now, let me explain to you the benefits of a cryptocurrency, right? So it might give a high return, and it is simple, it is fast, it is efficient, it doesn't require any paper currency, but it is typically very high risk also. And one of the major concerns that arise with cryptocurrency is the tracing the origin of transactions made through it. The anonymity that is there. So that is one thing which makes various countries think about what kind of laws should be put in place. And another problem that there is with crypto is that it is a very volatile thing, right? It fluctuates a lot. It can lose its value anytime. So given the nature of these currencies and the fact that there are very new concept in this world, countries have started framing different kinds of policies on different elements of crypto, and India is no exception. India has also framed laws and policies on cryptocurrency. So let me tell you about the legal and regulatory developments step by step what have happened so far in India. So first of all, let me tell you about this judgment by the Supreme Court of India, which was called the Internet and Mobile Association of India versus the RBI. And before I get to the details of this case, let me give you some context and a brief background of the case itself. So the RBI, or the Reserve Bank of India, had started giving warnings to the public about the risks of cryptocurrencies from the year 2013, itself, via press releases. And then an interministerial committee was formed to legislate on crypto. And this committee came out with a bill which actually proposed an alright ban on cryptocurrencies, which was called the Crypto Token and Crypto Asset Banning Control and Regulation Bill of 2018. However, this bill never came into force and crypto was not banned in India. Then, in April 2018, the RBI issued a circular banning regulated financial institutions from providing services to businesses which dealt with or exchanged in cryptocurrencies. And this circular shook up the entire cryptocurrency ecosystem in India. Some of the reasons given by the RBI for imposition of the ban were concerns over consumer protection, market integrity, and money laundering. And the validity of the circular was challenged then before the Supreme Court in various writ petitions led by crypto trading entities. And all of these petitions were then tagged together and heard by the Supreme Court, which delivered its judgment on the circular then in the case of Internet and Mobile Association of India versus the Reserve Bank of India. So the Supreme Court examined this issue in detail and struck down the circular. So while there were several issues that the judgment took into consideration, I'll only touch upon the two main contentions that were made by the petitioner or the Internet and Mobile Association of India. And this was, first of all, they basically tried to contend why cryptocurrency didn't fall within the definition of money and could not be regulated by the RBI. So to this, the Supreme Court said that cryptocurrencies did have the fundamental elements of money, such as being a medium of exchange and a store of value and a unit of account. The petitioners then contended that there was a fourth element of money also which cryptocurrency didn't have, which was that it wasn't a standard of deferred payment or something which you could use to make a purchase on credit and pay for later. So the Supreme Court rejected this argument and said that the RBI has the power to regulate anything which has the potential to impact the financial system of the country, right? Even if it doesn't really form a part of the credit or payment system. And so what this means in effect is that cryptocurrencies can still be regulated by the RBI. Now I'll discuss the second main argument by the petitioners in this case and the Supreme Court's ruling on that contention. The second argument was that the RBI circular was violative of the fundamental rights of the petitioners under Article 19(1)(g). Now, Article 19(1)(g) under the Constitution of India is the right to freely carry out trade and business, right? So basically, these exchanges, who were the petitioners, or the IAMI, which was the petitioner, said that since this is restricting business, so it is a violation of Article 19(1)(g). So while the Constitution gives citizens the freedom to carry out any business, it also gives the right to the state to put restrictions, reasonable restrictions, under Article 19(6) on this fundamental right. So what basically this means is, as per various judgments of the Supreme Court, is that reasonable restrictions can be placed on fundamental rights which are proportionate to the end that they seek to achieve, which means that they cannot be excessive. There has to be some proportion and balance between the measure that is being imposed and its effect, right? So over here, the Supreme Court basically found that it was quite disproportionate. The circular, which was brought about by the RBI, was very, very excessive and disproportionate to the end that it sought to achieve, and hence the circular was struck down. So then, after the judgment was passed in 2020, on May 31st, 2021, the RBI released a circular informing financial institutions that in light of the Supreme Court judgment, the earlier circular of 2018 was no longer in force and that they were now free to deal with cryptocurrency exchanges. So the judgment then set this a ball rolling on the recognition of cryptocurrency as a legal and valid concept in India, and a slew of regulatory measures and developments then followed, granting validity to crypto. So another bill was then introduced in 2021 called the Cryptocurrency and Regulation of Official Digital Currency Bill in the Lok Sabha. And the Lok Sabha is the lower house of the parliament in India. So this bill seeks to create a framework for creation of an official digital currency to be issued by the RBI, right? And on the surface of it, this bill seems to be quite restrictive, to be very honest, because it bans all private cryptocurrencies and their mining and trading, with very few exceptions to promote the underlying technology of cryptocurrency. So the only exception that it really makes is for an official digital currency to be brought about by the government itself, right? And this basically goes against the very concept of a cryptocurrency, which is that it should be decentralized. And this was the bill, right? And then there was another recent development which sort of slowly started bringing cryptocurrency in. So this bill, okay, first of all, let me tell you, this bill that I just talked about, it has not been brought into force, right? It's just a bill. It's not an act yet. So as of now, cryptocurrency is legal in India. And then to further clear the picture, there was a circular again released by the union government, right? About about a 30% tax, right, which should be levied on any earnings made from the transfer of virtual assets, including cryptocurrencies and NFTs. And this circular was released in June 2022, as per which 1% TDS will be deducted on the buyer's payment. So this TDS is only levied where the threshold of rupees 50,000 is exceeded in the case of specified persons, and rupees 10,000 is exceeded in the cases of other than specified persons. So basically, let me tell you what is a specified person and what is an unspecified person under these laws. So, specified person is any individual or Hindu undivided family which does not have any income under profits or gains of business or profession, or which has income under profits and gains of business or profession, but the gains from business do not exceed rupees 1 crore, or the gains from the profession do not exceed rupees 50 lakhs. So basically, this is a very broad category of people. This means basically all salaried people and all people having a business or being in a profession like law or chartered accountancy, where their income simply does not exceed rupees 50 lakh in case of profession and rupees 1 crore in case of a business, right? And all of these people basically do not have to pay that 1% TDS, or the 1% TDS will not be deducted if a payment is made by them. And further, about these tax rules, there was a regulation that if the investor's PAN is not linked to the virtual digital asset or is not available at the time of virtual asset realization, the tax will be deducted at the rate of 20%. So apart from that, if the individual investor fails to file the income tax return, tax will be deducted at the rate of 5%. So these are the tax regulations that were brought about with regard to crypto, which sort of gave people the signal that slowly cryptocurrency is becoming a part of the legal system in India. And then most recently, in March of 2023, there has been another development. The Finance Ministry has tweaked the anti-money laundering law by bringing cryptocurrencies and other virtual digital assets under its ambit. So this means that exchanges, custodians, wallet providers, and others in the crypto-related trade will now fall under the Prevention of Money Laundering Act. And to be more precise, in its notification, which was dated 7th March of 2023, the industry announced that the exchange between virtual digital assets and fiat currencies, or one or more forms of virtual digital assets, and the transfer of such virtual digital assets will all now fall under the PMLA, or Prevention of Money Laundering Act. And also, the safekeeping or administration of the virtual digital assets and participation in financial services related to the offer and sale of virtual digital assets will be covered under the Prevention of Money Laundering Act. So I personally think that this is a very good move, as it means that cryptocurrency businesses will have to include necessary KYC, transaction monitoring, and so on in their processes. Right. These companies will basically now have to perform enhanced due diligence, will have to now make sure that the transactions being carried out are not shady, are not being done for the purposes of money laundering. And all this will help legitimize the otherwise murky world of crypto and encourage more transactions and basically encourage cryptocurrency in India. However, I do welcome comments from crypto experts on the possible downside of this move. And I also welcome comments and questions about the other aspects of the developments in crypto law and policy in India that I explained in today's episodes, or about the work that I've done in the past on crypto issuance related compliances in foreign jurisdictions. So I understand that there may be many such comments and opinions, as crypto is a fascinating element of these modern times, and it gives rise to a lot of concerns also due to its nature, especially the fact that making transactions through it often remains ambiguous or unseen. So I hope that you all enjoyed today's episode, and I look forward to seeing you again soon. Thank you very much.